Listen to myself. Myself is laughing at us.
I like the last part of your greeting to say you've got a small piece of what?
Very small. I'm telling you, very small piece of land.
Morning, colleagues. Morning, Prof.
Just tell the principal if he votes correctly today, he will get more land.
No, I will. I promise, and I'm going to persuade everyone. No, that's great, Prof.
Yes, are we ready to start? Honorable Gumede, are you out of the underground?
He's with us today.
No, hi.
Are you out of the underground?
Yeah, even yesterday, I just listened to you.
Wait.
No, it's very wrong.
No, listen to me. Please listen to me.
Listen, please.
We're in a meeting of the Ad Hoc Committee.
No, the culprits here, it's Mahlatsi and Mina. They always provoke the chair and say to the chair, I'm the favorite. Right? So that's what they were saying, Chair. That I am the favorite. But you know, I allowed then Ronnie to dominate so that it changes. And then Ronnie becomes the favorite. Back as an underdog.
They are still growing up. I know, Comrade Mine, I will protect you. Don't worry about the youth.
Always. I've written to her. I said, hey, you always protect me. When she said, anyway, I may have gone to some of the BGMs, anyway, that was good. I was just listening to you. You know, there were areas where I wanted to make some interventions, but I said it.
No, I know you make strategic interventions, not interventions under general.
But that's, I heard you talking about COSATU as well.
Wait. We'll have our session afterwards.
Comrade Minor.
Good morning, Honorable Chair and colleagues.
How are you?
I'm very good. Thank you very much, Chair. And your good self?
I'm good. And continue the good work of protecting the vulnerable, especially those who are under attack by the youth.
Yes, definitely I'll do so, especially when land matters are concerned. Thank you very much.
Yes. Okay. Honorable members, are we ready to start? Are we ready?
Recording in progress.
I think, Honorable Chair, Advocate Bonani would advise you accordingly if we do really have to, in terms of the quorum. Thank you very much.
Thank you, Honorable Mane. Advocate Ramano.
Good morning, Chair and Honorable members, colleagues. Yes, we have a quorum. We can start our meeting.
Okay, thank you very much. Honorable members, I will be guided by yourself. I think that we requested an input by the administration. I can see, as always, they've done a very good document which will make life easier for us. I wanted to propose that we allow them to present, but before they do so, I just wanted to say that I think we have really made real progress, and we are all backed by inputs from our principals. And what we have before us no longer needs political guidance from anyone, but really needs engagement among ourselves on the merits and demerits of the proposals. And what we need to do today is actually to go clause by clause and persuade one another, and where we can persuade one another, and then we vote on the clauses, so that at the end of the day, we have a text that can go for publication. And I think this also offers us an opportunity to deal with what was consistently raised, namely that the original bill was actually a compromise arrived at before all parties could make inputs. And so this process going forward will help us to address that issue. And there was also an issue by others who said that we are exceeding our mandate. But our committee decided that we are dealing with all the subsections of Section 25. And that is the approach that we're going to take today. We deal with all the subsections and take positions on them and come out with a single text that will be published for comments. The importance of these public comments would be to make the people themselves the arbiter. For instance, when we went out for public hearings, for instance, I don't remember us explaining, if we talk about state custodianship, I'm not sure that we had the same understanding of that with the public. And that's why even amongst ourselves, we are still debating that. So if we publish the new text, then we will have to ensure that our people engage with that concept, find out what it means. And then again, the question of a cutoff date. People were just taking positions whether or not they like the cutoff date, but no real study was made why that cutoff date came under consideration. So this second phase will also help us to guide the inputs as to why do we talk about cutoff date? Why is it an issue that has to be resolved with their inputs? In other words, the people themselves will be the final arbiter on areas of disagreements, and therefore there should be no fear that this process will be deliver the desired outcome. And I'm personally very happy, and I want to thank all of you for the robust engagements that you were involved in, because that's what debate, that's what Parliament is about. And you know, you'll agree with me that the rising infections and fatalities in the COVID pandemic are such that we can no longer wait for another year or 5 years to deal with the question of land, because we need social and economic recovery, and that cannot take place without the restoration, redistribution, and restitution of land to our people. So this matter that we are dealing with is really about the survival of the South African nation, and all of us must approach these matters with that in view, that this is an intervention that can save the nation. So let's put aside our personal or party interest and put the interests of South Africa and her people top on the agenda, and then we will have liberated our country and our people. But so far, I must thank all of you for the camaraderie or friendly manner in which you have worked with one another. listened to one another, took mandates from your principals. Now the ball is in our court. We have to deliver this project by the end of August. I thank you. Maybe I should just go back to check. Are you happy that we ask the administration, Dr. Tulisile is here, that they do the presentation, and then we note areas where we want to raise issues for a debate. And then, as I said before, we are politicians, will take political decisions, but the administration are providing us with the technical support, but they are entitled to express opinions, and if we differ with the opinions that they express, that doesn't mean that a war has broken out. It only means that as individuals, we are entitled to opinions, and we must be free to express those opinions without fear or favor. And I want to thank you and hear from you. Can we proceed as I propose that the administration presents the text that is before us, and then once they've presented, we have taken questions of clarity, then we'll go and then subsection by subsection, and where we don't agree, put the matter to the vote until we come to the end. Can I hear anyone who wants to make an intervention on the approach? Honorable Murasatu.
Good morning, Chairperson and all colleagues on the platform. Chairperson, I think your preamble, your opening remarks, and the proposed approach is going to assist us a great deal. And I therefore rise here to say I support that the route proposed be the route undertaken. Thank you.
Thank you, Honorable Murasata. Any contrary view? Honorable members, anyone who has a different view? Mary Bulelo, are you with us?
Yes, I'm here.
Okay. Honorable Mashatsi, Honorable Noku, Honorable Hendricks, Honorable Mandela, Honorable Charmaine, we are all happy. So now that we are all happy, I will ask Dr. Tulisile to guide us. How do we move forward?
Chairperson?
Yes, Advocate.
No, actually, it is legal services that should be presenting.
Oh, legal services. Thank you for the correction and guidance. Advocate.
Good morning, Chairperson. Good morning, members. It's Tilana Halley-Starkey.
Who's talking?
It's Tilana Halley-Starkey, Chairperson. I'll be standing in for Charmaine today. I'll be presenting the draft bill.
Okay. Thank you very much, and good to see you.
Yes, good to see you too, Chairperson.
And as I said, you did a good sterling job, and we are grateful to you for that. Proceed.
Thank you, Chairperson. Chairperson, as you pointed out in the start of this meeting, we had been tasked to draft a 18 constitutional amendment bill with the various proposals from parties who had contributed in previous meetings. We would recommend, Chairperson, and I'd like to share my screen at this point. Just give me a few minutes. Is the screen visible? I think so.
Yeah, yes.
Chairperson, before I continue, you had advised that we should present the entire bill and then deliberations would then proceed. Chairperson, the bill is rather lengthy and there are various proposals. if I may ask, could we pause at every clause? Could I present a clause with the opinions of members and then pause for deliberations? As I feel, Chair, it might be confusing if I present everything at one go. It might be overwhelming. I mean, I'm actually.
No, you are right. That makes more sense. Don't motivate any longer.
Thank you, Chairperson.
Honorable members will agree.
Okay, thank you, Chairperson. I'll start. So, to start off, members, I'd like to point out that those words that are in bold and in square brackets are deletions. And those words that are underlined are insertions. So members need to keep that in mind when we're going through the bill. With regards to the preamble, Chairperson and members, there's only one proposal made by Al-Jama'ah, and the first proposal is the insertion into the preamble, whereas an amendment to Section 25 of the Constitution has been considered by various committees of Parliament of the Republic of South Africa, and whereas the subject matter is highly contested. The first proposal was originally an amendment on expropriation, and the original amendment by Al-Jama'ah had used the term expropriation. We amended the sentence proposed by Al-Jama'ah to accord with the legislative prescripts. The amendment is an amendment to Section 25 and should rather be described as such and not that of expropriation. We cannot reference the expropriation bill in this bill's preamble, as strictly speaking, the expropriation bill is not in existence. So that is why Al-Jama'ah's proposal has been amended to read as displayed. It's not clear what the purpose is of this inclusion into the preamble. A preamble, as members may know, sets out the stage of the content of the bill to follow. This paragraph indicates the history and development of the bill, and we would recommend that this not be part of the preamble, but rather be part of the debate in the House. The second proposal by Al-Jama'ah is broken up into 3 paragraphs, which I've highlighted. These inclusions speak to land reform, and we've tried to correct the wording as best we could to be in line with drafting precepts. However, land reform in South Africa has happened post-1994 according to our constitution. And Al-Jama'ah has proposed to include the following. And whereas land reform in South Africa has to date incorrectly been based on European principles instead of principles prescribed by the African continent, and whereas the principles related to land tenure must not be modified by European law, but rather proper land reform should be executed. This paragraph implies that land reform to date has not been proper, and that our land reform programs, i.e. redistribution, restitution, and land tenure reform is founded on European principles, but not according to our prescripts of our constitution. The second paragraph states that there is an unequal distribution of land as a result of wrongful disposition of land in the past, which must be addressed in terms of a South African Black Revolution. This second paragraph is repeating the last paragraph of our currently advertised preamble. Furthermore, it is not recommended to refer to words such as revolution in a preamble, unless it is made clear what that word in turn is meant. The word revolution can sometimes have connotations of forcefully overthrowing social order or government, which the committee has on more than one occasion said that it is against this. The third insertion, as suggested by Al-Jama'ah, is whereas there is a concern that Section 235 of the Constitution must not impact on land reform. The third paragraph also has no meaning in this preamble. If it is a concern that Section 235 of the Constitution, which is the right of South African people to self-determination, would impact land reform, then it should be included in the bill, and it has not been included. It should not only be stated in the preamble, but also the committee has on more than one occasion expressed that it is tasked to only focus on Section 25 and not other sections of the Constitution. At this juncture, I'd like to pause for the committee to please vote on the inclusions of these four paragraphs into the preamble as suggested by Al-Jama'ah.
Honorable members. Honorable members. Yes, Honorable Dr. Meldam and Honorable Dr. Lotrich, in that order.
Yes, thank you, Chairperson. I would first react to say that sir. No, I
didn't
would
hear
first react
you.
to say in terms of my perception. Can you hear me, Chairperson?
Now I can hear you, Doctor.
Thank you, sir. No, I would like to start off by saying that in terms of my perspective from the Freedom Front Plus's point of view, that the processes that we are busy with has absolutely nothing to do with Section 235. It's something completely different. And I agree with the interpretation by legal services in general that none of these proposals should be included into the preamble. That's my view. Thank you.
Thank you, Dr. Honorable Dr. Lotrich.
Good morning, Chairperson, and good morning, colleagues. Yes, the DA is also not in favor of these proposals as mentioned or included by Al-Jama'ah, and we also fully support the interpretation given by legal services, so we are against these inclusions.
Thank you, Dr. Honorable Lesuma.
Good morning, colleagues, and thank you very much, Honorable Chair. I will move and suggest that we remain with the preamble as advertised for now, because we're still going to come back, but for now we just leave it as it is, as advertised. It was advertised. Thank you very much, Chair.
No, thank you. I think as it was pointed out, some of the matters raised by Al-Jama'ah belong to a debate. So I hope they will understand that. Honorable Rosetta.
Yes, Chairperson. I also wanted to rise in support of Honorable Lesoma to say it would be a little bit premature of us to just say, let's face off. And moreover, that it's not the be all and the end all now as we speak, but we are still going to debate and fine tune. And as a result of that space, which is still lying ahead of us, I propose and support Honorable Lesoma that we leave with that preamble as presented by Al-Jama'ah. Bayaranki, voorzitter.
Bayaranki, Mrs. Haley, are you happy with the inputs?
I am, Chairperson. I would like to just make a note of that.
Oh, sorry, before you proceed, I see another hand, Honorable Hendricks. I can't hear you. Can you unmute?
Thank you very much, Honorable Chair, and thank you very much for at least addressing the position of Al-Jama'ah. And we agree with the proposal of Comrade Lesoma that we stick to the advertised version of the preamble. And we say that in the spirit of making progress. And we hope that we're now setting the trend for the rest of the meeting, that members of the committee can give and take so that we can bring this matter to an end. Thank you very much, Honorable Chair.
Thank you very much. And as I have consistently said, all proposals will be considered on their merits or demerits, regardless of the size of the party that is making an input. So we are all equal in the sense that what the inputs made are considered on their merits, not on the basis, other basis. Advocate Haley, can we proceed?
Yes, Chairperson. The next The next clause that we'll deal with is clause A, which is an amendment to subsection 1 of section 25. And this clause is a proposal by the Freedom Front Plus to delete no and include everyone has a right to own property and no one may be deprived of property except in terms of a law of general application, and no law may permit arbitrary deprivation of property. This new wording is to make the right positive. This new insertion and deletion will have to be published for public comments in terms of section 74.5a of the Constitution and National Assembly Rule 275a. It will also need to be sent to the provincial legislatures in terms of section 74.5b of the Constitution and to the National House of Traditional Leaders and Khoisan leaders in terms of the classification of the bill, and seeks inputs from the department in terms of National Assembly Rule 275b. We'll also further need to ask permission to approach the National Assembly for permission to extend its current scope or mandate of the bill in terms of National Assembly Rule 2864b. At this point, I'd like to pause for the committee to deliberate and vote on the inclusion as suggested by the Freedom Front Plus.
Honorable members, you have heard for yourself that the proposal will require many other things to be done. So let's hear what's your take on that. I don't see any hands. I see Honorable Lesoma.
Thank you very much, Chair. For me, I'll move that for now we don't agree with the proposal. We'll leave it. We'll see it when we come back if need arises. But we omit it here. Thank you very much.
Okay. Any other hand? Any other hand? Honorable Dr. Mulder.
Yes, Honorable Chairperson. I propose
maybe
that
before you speak, let me take Honorable Mahlatsi so that in case you were to respond to them, you are free to do so. Honorable Mahlatsi.
Thank you very much, Chair, and good morning, colleagues. Chairperson, I stand to support the view of Honorable Soma. Thank you.
Okay, Dr. Mulder.
Yes, thank you, Chairperson. I proposed this amendment on behalf of the Freedom Front Plus originally, when I said that our view is that we should not amend the specific section of the Bill of Rights, but if we do, then the correct thing would be to amend as I have proposed. In other words, if you look at the Bill of Rights, you'll find that 90% of each and every right stipulated in the Bill of Rights are framed in a positive manner. Everyone has the right to fair labor practice. Everyone has the right to freedom of movement. And I can continue in that vein. And I am of the view that the right to own property is a positive right that you will find in almost every constitutional or a democratic state throughout the world. It's just a positive thing to formulate and to include in the Bill of Rights. Now, currently, this right is framed in a negative manner, may not be deprived of, but I thought it was a positive thing to frame it in a positive wording and then continue with the section as is. I've taken note of what the legal services says in terms of the process and understand that, but that is why we proposed that. Thank you, sir.
Okay, thank you. Any other hand? Honorable Murasata.
Prof and Chairperson to this all-important committee. Let me rise and say, you see, there is a reason I rise here to support what Honorable Soma, also seconded by Honorable Matladze came to the fore. But with regard to what Honorable Dr. Melder is trying to refer us to on the Bill of Rights, Chairperson, you will understand that we are having a process, the process wherein we seek to correct the ills and the wrongs. And as a result, we have to be very careful of the manner in which we are going to quote the Bill of Rights. Because at the end of the day, in our zeal and endeavor to make a correction, the right that derives itself out of the wrong done ceases to be the right. And for this reason, I would say, in as much as the Bill of Rights is correct, let us also say we have to use it economically. Otherwise, it is going to overtake the intended course for which we want to go. Thank you very much, Chair.
Thank Honorable Member. Any other input? Dr. Melder. Dr. Melder.
Yes, Chairperson.
It would seem that the proposal you are making, which you have well motivated, would complicate our process further. I am of the view that although that provision is couched in a positive, in a negative way, it would actually not prejudice anyone. And I'm inclined to agree with those who says we should leave it as is. Will you be comfortable? But if there's an argument you want to raise, you reserve the right to do so. That for now, let's stay with what we have. Yeah, you can respond.
Yes, you've asked me a question. I would like to reply if possible. I hear what you are saying.
Yes.
Obviously, I'm not comfortable if you want to remove my proposal, but that may be so. I just want to make sure that you've also mentioned that it will complicate the process, and that because certain things will then have to be done in terms of the process going back for as extended mandate and other processes. And I just want to ask that you would then continue throughout the process and keep that in mind when we come to other proposals as well. Thank you.
Thank you. Advocate Haley.
Thank you, Chair. I will just make a note of that before continuing. The next clause is, Chairperson, I see that there are hands. Can I continue?
Yes, thank you. No, don't. Let's hear first the hands. What are they saying? Honorable Shibambo?
No, Chair, I think what is being proposed is problematic. What is being implied here is problematic, because I thought we have resolved this thing long time ago, that there is no long process that is going to be followed in terms of amendment of Section 25. We have dealt with that question long time ago. We've taken a decision in terms of us amending every section and subsection here in Section 25. So this suggestion or supposition that we should go through a publication of the bill again and everything is problematic. Can the people of legal office just read what is here as options, and then we'll deliberate without trying to give innuendos that there must be a different process? We have rejected that opinion long time ago. Let's live with this, what we have now, and then we'll vote on it. And in legal office, we've listened to you. We have not accepted your advice in terms of how this process must be followed.
Honorable Shibambo, we're engaged in a process. This is another stage. They are presenting in terms of the mandate we gave them at the last meeting. Now let them present as they do, and where we disagree, we reiterate the disagreements, but we cannot carry over disagreements of the past into the future. I think let's proceed as we are doing, but where you feel we have already decided, restate the decision and see if everybody agrees with the input, so that the whole thing should roll out in an orderly fashion. Honorable Gumede. Honorable Gumede.
Chair.
Yes, you are on the floor.
Yes, Chair. I think I'm mainly covered by the colleagues, especially Honorable Lesoma, Atlanti, as well as Ronnie. But what I wanted to say, Chair, is we have a very high responsibility. The responsibility is, when we were tasked, is that we make whatever is implicit, explicit. This comes from there. We cannot then begin to confuse the masses. The assertion as it was or were, I think it's fine, Chair. Let's leave it like that. And especially because even Dr. Murde has, in fact, my understanding is withdrawing whatever he has proposed. So if we may move forward, all what we are saying here, we want to make explicit what has been implicit. So we can't tamper then with the clauses.
I actually thought that you have helped us to round up the consensus on the matter. But I see Dr. Mulder is raising his hand, and let me allow him to speak.
Yes, thank you, Chairperson. I just want to give clarity. I'm not withdrawing anything. I'm just taking note of that. And if the majority in the committee does not support that, then so be it.
I think that's very progressive, Dr. Mulder. You accept the position of the majority as rounded up by Honorable Gumede. I think we should stay with that. Honorable Mahlatsi.
Thank you, Chairperson. I just want to the meeting to take note of the input by Honorable Mulder, Dr. Mulder, in his response when he was responding to myself and maybe to the committee, in as far as your response with complicating the process and how the matter there must be consistency when other issues the other clauses are concerned. I think we shouldn't approach this meeting in that fashion. And I don't think the chair, when he meant complicating the issue, he meant in as far as redoing or rearranging our mandate. I think we must take this process in the spirit that says we accept the initial clause as it was, not necessarily that there will be complications with other. I don't think that the context in which the chair was raising the complications was in the manner in which you might have understood him, so that we do not want to create an impression that what we have done here must be done everywhere else, in as far as not that we must be inconsistent, but his view on the matter was that majority is agreeing here. Let's move along those lines. Not that there will be a different process or anything of that sort. Thanks, Chair.
Honorable Mahlatsi, thank you very much for clarifying what I had said. That's precisely the correct explanation that we have given. We can proceed. Honorable Shibambo.
No, but also this notion that the sole mandate of this committee as established is to just initiate and introduce the amendment to make implicit what is implicit. It's minimalist, it's reductionist. The mandate also includes that in the process of amending Section 25, the committee must have regard to the work done and recommendations as contained in the reports of the Constitutional Review Committee and the previous ad hoc committee on amendment of Section 25 of the Constitution. To then just reduce it to making explicit what is implicit is problematic. It's not the mandate of this committee. We have agreed to have dealt with this long time ago, that we have the legitimate and a right and mandate to amend all subsections in section 25 without having to go back through the process, which every time legal office speaks here is trying to smuggle as if that is what we have agreed upon. So legal office must just present what we have here, and then they'll give their opinion later on in terms of the whole process without bringing this issue which we have deliberated on and rejected. We have rejected with contempt this suggestion that we must have to go back if we want to change some sections that are not in the draft bill. We are doing this bill in its entirety and we're deliberating on its entirety, voting on it now. We might not agree and then we'll then decide what then becomes the way forward.
Honorable Shibambu, but before I comment on what you are saying, I see other hands. Honorable Melda, Dr. Melda, Honorable Busiso, Honorable Mahlatsi. Can I take those comments, your contributions?
Yes, thank you. Yes, thank you, Chairperson. With all due respect, maybe Honorable Shivambu attended a different meeting. I was not in any meeting where the views of the legal services were rejected with contempt. That's not correct. That's factually wrong. The fact of the matter is that when our mandate was again reviewed, or when the decision was taken that we are then given a new date, Parliament in the resolution clearly stated that we've got exactly the same mandate as original. It was not, the scope was not broadened in any way. And I would suggest that we continue with what the legal services are putting on the table at the moment. Thank you.
Thank you, Dr. Mulder. Honorable Gumede.
Chair, it may be appropriate. There are times we don't deal with semantics. We disagree for the purpose of perhaps just disagreeing, not guiding us so that we move forward as a committee. I think you made a very clear opening here, which was in fact supported by the Miss or Mrs. Haley, right? That we deal with clause by clause. The comment I've made is relevant to the clause. Other sections, we may use the different approaches. Let's not make this a blanket kind of an approach, that if one has made a comment on this particular clause, and then we begin to apply that in all other clauses, we may have, or we are going to have, different approaches. So these are in fact just semantics. All these things that we are saying are covered, they are there. So Chair, I wish we move, because at the end of the day, we had already accepted, especially the mover of such clause has accepted that if the majority feels that this clause be not accepted, is going to be happy. Thank you, Chair.
Thank you, Honorable Gumede. Honorable Lesuma.
Honorable Chair, let me step down for now and allow you so that we can proceed as per your opening remarks, which I thought they were very helpful. Thank you very much.
Thank you. Honorable Shibambu. There's an old hand. I think Honorable Gumede has helped us.
It's not an old hand, Chair.
Okay, proceed.
Remember, we had deliberations before on whether we should discuss the entirety of section 25 and all subsections. And there was a view that we can't discuss the entirety of it. We must just reduce our deliberations to the subsections that are contained in the draft bill, that if we want to deliberate on all other subsections, this process has to be restarted must go back to Parliament for a new mandate and a variety of other things that had to be followed. And we took a decision as this committee that we're going to deliberate on all the subsections. We did not accept that guidance from the legal office. That is why I'm saying that, because we are now deliberating on all the subsections, there's no need to always try to smuggle a perspective which in principle we have rejected, because we then said we're going to deal with all subsections. That is why this draft bill now, which is being presented, has got all the subsections and proposed amendments. And to always say that, no, this one will need Parliament to re-debate and remand it, it's problematic. It's not what we've agreed. That is not the basis. That's not the foundation upon which we're moving from. I think that has to be clear.
With respect, Honorable Shibambo, I don't see where the problem is, because we have agreed, as you correctly say, that we're dealing with all the subsections, and legal services have agreed as well. And they even requested that we deal with one section, conclude it, move to another one. So I don't see the basis of any disagreement. But I think Honorable Gumede has assisted us as well to say, let's not take a blanket approach. Let's deal with different clauses differently. We mustn't say, because we approach this section this way, then mutatis mutandis. We shouldn't do that. I think we have, we should have an agreement now to move forward. But I see Honorable Lesoma. I will allow her to make an input.
No, Chair, it's a delayed hand. You
okay, no, that's fine.
Allow me to speak.
Okay,
Thank
I think
you very much.
we are in agreement that we move forward. Honorable Advocate Haley, proceed. Advocate Haley.
Thank you, Chairperson. Thank you, members. I'll continue. The next clause is clause B, and there are two proposals. The first proposal being by the ANC and Al Jamaa, and the second proposal being by the EFF. The first proposal, members will recall that the original bill as advertised included a word court, and that the courts would be the decision maker. The proposal by both the ANC and Al Jamaa now deletes the word court and includes a new section saying, provided that where land, a new sentence saying, provided that where land and any improvements thereon are expropriated for the purposes of land reform as contemplated in subsection 8, the amount of compensation be null. There is a differing view of whether we should advertise the removal of the word courts. The Constitutional and Legal Services Office is of the view that the word court and the deletion of the word court would have to be published for public comment and sent to the provincial legislatures and the National House of Traditional and Khoisan leaders. And the committee will then also have to seek inputs from the departments should we wish to remove the word court. However, committee support has said that this is a technical amendment and it was in the bill as advertised, and the amendment is the result of public input.
Advocate Haley, are you still there?
Sorry about that, Chairperson. The joys of working from home. The EFF proposal is that is also an amendment to subsection 2. And that is so that property can be expropriated without compensation in public interest and only in the terms of a law of general application. Therefore, deleting only the words a law in terms of general application, and then also deleting subject to compensation, the amount of which and the time and manner and payment of which have either been agreed to by those affected or decided or approved by the court.
Just hold on. Honorable Kava, is that a point of order?
Yes, slightly, Chair.
Yes, proceed.
May I request the legal advisor?
Recording stopped.
not to repeat what is in the legal opinion already. Let's take that as noted, and so that we don't come back to debate, the what next, and conflate it with the presentation she is making. Let's deal with the clauses. Once we are done with the clauses, we'll then turn to what next. The what next is the guide that is in the legal opinion. And I think it will assist so that we don't provoke a discussion as you make your presentation. Thanks.
Advocate Haley, are you comfortable with that?
Yes, noted, Chairperson and Honorable Kaba. I won't go into details with regards to procedure in terms of advertising and asking permission, but may I, if members are comfortable with this, may I comment on drafting prescripts and the reasons why we have made amendments to proposals as suggested by parties, and also legal argument in terms of why certain proposals might appear in a different format to what members had suggested.
Just hold on, Honorable Lesuma. Honorable Lesuma.
No, Honorable, thank you very much, Honorable Chair. If I heard Honorable Klaba correctly, he's not saying that she mustn't make a legal opinion on that, but he's saying that let's separate the processes. Let's deal what is before us in terms of having an agreement in what is going to be advertised. And then we'll follow then what next, and then that's where they are going to come in. Otherwise, if you engage in the clauses that we have not yet decided as the committee through the correct processes, then it will confuse the whole discussions. We'll end up bouncing to and fro. So that was he was saying, not to say that we're not going to allow them to listen to their views as legal services of Parliament, as it were. Thank you.
Yeah, Advocate Haley, I think this is a proposal actually just to help us not to get confused. That we separate this. You will still have to do that, present the opinion, but let's first focus on the text. Can we go that way? Proceed.
Chair, I do see hands that have been raised.
Sorry, Honorable Shivambu, did you want to say something?
Yes, I'm saying like this is quite simple and straightforward. There is a draft bill which is being presented here with phrasing options from different political parties. What the legal office must be doing now is to read word per word what different political parties are saying. And then we as the committee members will deliberate on which option do we go with. They must not smuggle legal opinion. They can do that later. We're not interested in that. We have listened to that before. We can listen to it again and everything else. But now we're presenting the text of the bill without all these innuendos which are being smuggled here. It's not necessary. It's just going to make this process unnecessary.
Honorable Shibambo, I think you agree with Honorable Kawa and Suma, but I don't agree with the word smuggling, because I gave them the permission to present that way, but now members don't agree with that approach, which is their right to do so. And they are in agreement with what you are saying. But you see, we shouldn't use negative terms. Smuggling suggests that someone is a crook or doesn't have integrity. They do things they shouldn't be doing. I don't think we should treat colleagues and members of the staff like that, because I don't think they are smuggling anything. I allow them to present that way. But now that the three of you or the committee feels we shouldn't approach the matter that way, we accept that. So we shouldn't cast aspersions on professionals. These people are professionals, and their professional integrity is very important. Proceed, Honorable Advocate Haley.
Thank you, Chairperson. At this juncture, I'd like to pause for the committee to vote on the amendments as suggested and the proposals by these three parties.
Okay. Honorable Dr. Lotrich and then Honorable Shivambu, in that order.
Thank you, Chairperson. In terms of the proposals by the ANC and Al Jamar, the DA does not support that. We also agree with the notes given by the legal services in terms of taking away any position of the courts. And then also a major concern, which I also highlighted last week during our discussions, is that we are still extremely concerned regarding the fact that we include in the Constitution a provision which says that land and any improvements thereon be expropriated for no compensation, as the economic and financial impact assessment of that has not been done. And I know, Chairperson, you said last week that this is not the place in the Constitution, that we don't have to do such an assessment, but we believe that the consequences and implications for the country will be far-reaching, and also the fact that the whole process that we are busy with now was couched in the words of the President that there will be no negative effect on the economy or food security. So for those purposes, we cannot support the ANC and Al Jamar proposal. The EFF proposal we definitely cannot support, as it takes out the whole compensation part, and that land is then expropriated just in terms of a law of general application, which we feel the threshold is too low, and we therefore cannot support that, and that takes out the role of the court totally, something that we also find will be totally against Chapter 1 of the Constitution, the founding principles. Thank you.
Dr. Lotrich, don't you think that that assessment, financial and economic assessment, belongs to the phase of implementation? Why should it be relevant at this stage? Because we are amending the Constitution, which has got to be implemented. Now, what we are talking about belongs to the implementation phase. Can you just address
Chairperson, I don't agree with that. I think it would be extremely dangerous and risky to embark on a constitutional amendment of which consequences we have not yet determined. And I also base this on some of the submissions that we actually received, that there will be far-reaching consequences, and we have to be cognizant of that. We can't just carry on regardless. We have to take note of that.
Okay, no, thanks. You have explained yourself. Dr. Mulder? Honorable Dr. Mulder?
Yes, I'm here. Thank you, Chairperson. No, thank you, Chairperson. The Freedom Front Plus will not support the proposal by the ANC or Al Jamar. The role of the court should not be tampered with. I think that would be in conflict with Section 34 of the Constitution. It will be unconstitutional as such. Read also with Section 1 that deals with the rule of law. And we will also not support the proposal by the EFF. Only in terms of the law of general application is open, as far as we are concerned, for abuse, and we will not support that.
Thank you. Honorable Shivambu?
Well, thanks, Chair. We, as the EFF, reject the ANC's suggestion and submission that property may be amended subject to compensation. We do not think that the word subject to compensation must be retained in the Constitution. We think that this process in the first place was to deal with the issue of expropriation without compensation. That is what we reject. So we reject the phrasing of the ANC. We do not think that even the inclusion of nil compensation in certain circumstances does not cover the intent of expropriating and repossessing our land without compensation. And our proposal, as is contained there, is that subsection 2 of Section 25 must read as follows: that property may be expropriated without compensation, and A 2A must read as only in terms of law of general application, and B, for a public purpose or in the public interest. And of course, that synchronizes with the later section in section 25 subsection, which says that public interest and public purpose includes the nation's commitment to land reform. But we think that to make it much more concise and cogent, it must read as property may be expropriated without compensation, expropriated without compensation, only in terms of law of general application and for a public purpose and in a public interest. And we reject firmly the ANC's submission.
Okay, Honorable Lesuma. Honorable Lesuma.
Yes, Honorable Chair. Thank you very much for the opportunity. I'm not a person that would wish to listen to her voice all the time. ANC have made a number of meetings, its submission and motivated and make a very legal sound arguments. Today we're not intending to repeat ourselves. I will move formally, Chair, that the committee adopts for the purpose of publication for 3 weeks that the text as presented by the ANC, and we appreciate the support of Al-Jamaa presented by the ANC, be the one that goes out for publications for this purpose of this round. Thank you very much, Chair.
Honorable Mahlatse.
Thank you very much, Chairperson. Yeah, thank you very much, Chair. And first and foremost, I want to second the move by Honorable Zoma. But I think as much as we agreed in principle that today we are not necessarily going to engage and discuss, because we have done this thing for the past, I don't know how many months, where we were trying to navigate through the process in influencing one another. But I think it is important maybe just to make reference to what Dr. Lotret has indicated, that the implications therefore and so on. I think we have made it very clear that we need to distinctively separate the processes in as far as the state is concerned. We understand very well that our responsibility here as a legislators is to amend constitution. However, the process in terms of implementation lies with the executive. And we have made it that point explicitly on numerous occasions. But one issue that I want to speak to is around the implications in as far as the finances are concerned. You know, it's quite funny that the DA comes gun blazing on this issue, because I'm not sure in 1913 when this decision was taken, did they think about the implications, then the far-reaching implication in this far, and as far as land is concerned, when 86% of our people, African people, have got absolutely no land. And as a movement today, we are bringing a legit process to include them in the process of negotiating. However, when our people have suffered for many years, and today we've got the audacity to come to this meeting to say there will be implication. Did they think about it many years ago? Did they think about the implications of this particular? But however, let me stop there. But we must indicate that it's quite worrisome that 27 years in democracy, we still have people thinking in that particular fashion. Thanks, Chair.
No, you are not out of order, Honorable Mahlatse, because this problem of violent land disposition can be taken as far back as the end of the 17th century. And at all stages after the First Anglo-Boer War, the Second Anglo-Boer War, the Union of South Africa, 1930, nobody ever considered the implications and say we can't change the law because we don't know the implications. So I think you are perfectly right in your observation. I had seen the hand of Honorable Kawa, but it has disappeared. I don't know whether he withdrew it, but in the meantime, I will allow Honorable Stein, Annette Stein, and then Honorable Melda to address us.
Thank you very much, Chairperson. Unfortunately, I can't switch on my video for unstable network. Chairperson, I totally disagree with the sentiments that was just raised by yourself and the Honorable Matlatsi before you. I think it is unfair to say that the DA is not caring about people and that we never said anything about this. I think that if you read back in the history, you will see that the party and our predecessors always said that we support land reform. What we don't support is that the fact that the Constitution is the problem and we have to change the Constitution. Chair, I want to raise my objection with the fact that we are being clustered just because it sounds like our race or skin color in this instance, and we object to that sentiment that was just raised. Thank you, Chair.
With respect, Honorable Stein, there's no racism involved here. Honorable Matlatsi is dealing about factual situation, evidence-based, that throughout this 25, before 1994, people were changing laws which have implications for the indigenous African people without regard to the negative impact of those things. So she's not raising any racial thing, so don't attribute any racist attitude to her, because that's not what she's done. Honorable Dr. Mulder.
Yes, thank you, Chairperson. I was under the impression that we're not going to have a discussion now, but if you want, we can do that.
Chair, I agree with Dr. Mulder. Can we move forward?
Yeah, yeah, but he has not finished speaking. Let him finish speaking. Dr. Mulder?
Yes, no, well, I think the question of financial implications is actual very relevant. And if you look on page 11 of the proposed draft bill under point 4, it says financial implication for the state, none. And I think that is in a dispute. And just for, I'm not referring to the past, I'm referring to the present in terms of the whole question of who takes responsibility for all the financial implications in terms of properties that are bonded if they are expropriated. I don't think we have an answer about that, but be that as it may. I want to raise a technical point, Chairperson. I think we should be very sure in terms and make sure that we are technically correct. If you put this sections now and there are a difference between parties, I just think we should make absolutely sure that the members who are eligible to vote in the committee should be present. And perhaps we should note that in terms of, I'm not sure if it's safe to go by the way of just saying, Honorable Soma says so, and then this is the majority. I do not know if the voting members are all present, and maybe administration can assist us in identifying the voting members in terms of the ATC when the committee was set up. Thank you, Chairperson.
I will do that for the ANC.
Yeah, thank you, Honorable Melda, for that guidance, because with respect to the other sections, there were no problems. But going forward, starting with what is before us now, we will need to follow what you are doing and check the voting members, and then we have to vote when there's disagreements, so that what goes into the text will be what was approved by the majority. Honorable Kawa, you wanted to come in. Honorable Kawa?
Chair, no. Correct, Chair. Chair?
Yes, proceed.
Chair?
Yes, proceed.
Yes, no. I was actually, yes. Chair, I was actually saying that we have deliberated on these clauses at length, and the motivation is now known. And so I think Dr. Mulder was suggesting that we focus and vote on the clauses. And if in the end we still want to take political discussion on any of them, we can still do it. But let's not conflate voting, which this meeting is now about, and further deliberation as if, and in fact, in the deliberation, we're not making any new point. You know, these points have been canvassed many times in all the meetings since the last. We started deliberating on public submissions. So I thought we should limit on that, focus on voting, and if in the end we still want to take political discussion, let's do so. You know, but we must, and then deal with the process, the where to and what next, and towards the end of the meeting. Thanks. But
yeah, no, I don't think.
Chair, Lesoma is going to give you the names of the voting ANC members. Thanks.
Okay. No, I don't think that we are debating again, but I think the intervention by Honorable Mahlatsi could have been brought as a point of order. But I think it was appropriate that she raised that, but it's not suggesting that we are going to debate. You are right. It's about voting now. We should go that way. Honorable Lesoma, can you guide us as proposed?
Thank you very much, Honorable Chair. It's so difficult to be the chair because when somebody raises a hand, you don't know what his or her hand is going to say. But nevertheless, Chair, voting members from the ANC, it's Honorable Prof. Motsecha, who's chairing the meeting, Honorable Dibulelo Mahlatsi, Honorable, I'm reading from here in terms of who is present, Honorable Nolita Tobongwane, Honorable Nkosi Zweli Velile Mandela, Honorable Lesoma, Honorable Spusiso Gumede. Six members of the ANC are voting members. Two are alternate members, and one it's Honorable Kaba, who's a non-voting member, but he's got all the rights to participate fully in the committee as gazette as 80 seat. So I've stated to you in terms of the warm bodies which are here. Let me repeat it slowly. It's Honorable Prof. Motsecha, Honorable Lesoma, Honorable Mahlatsi, Honorable Gumede, Honorable Ronim Rasetla, Honorable Nolita. She's an alternate. She's here. That makes it 6 in terms of the voting members. In case the system takes anyone out from the ANC, Honorable Mandela is here as well, and then the non-voting. So I've explained it and I've made it explicit in terms of the voting members from the ANC. Thank you very much, Chair. Honorable Bongo has got a standing apology. Thank you very much.
Okay. Now there is a proposal by the ANC, which is rejected by the EFF and the DA. So we are going to, but before we go there, from the DA, how many voting members do you have?
Chairperson, we have 2 voting members. It is myself and Honorable Breitenbach, and we are both online and present, and an alternative voting member is Annette Stein, and we also have other alternative members online. So we are 2 voting.
Okay. So, Honorable Lesoma, can we formally put, oh no, sorry, Dr. Mulder, how many are you? Dr. Mulder?
Chairman, the FF Plus is entitled to 1 member, and it's me, and I'm the voting member on behalf of the FF Plus. I think the IFP has got one voting member as well as the EFF.
IFP, one member. EFF, one member. Okay. The proposal by the ANC, can we formally have it put forward, and then we see how many people support it?
Thank you very much, Chair. I will do it through reading it as beamed.
Yeah.
Subject to compensation, the amount of which and the time and the manner of payment of which have either been agreed by those affected or decided or approved by court, provided that land and any improvement thereon are expropriated for the purpose of land reform as contemplated in subsection 8, the amount of compensation may be nil. Thank you, Chair. I move for the adoption of the ANC proposal. Thank you very much.
Any seconder for that proposal? Honorable Murasatla?
Seconded, Chair.
Okay.
Chairperson, I wanted to make things formal. You have identified me. My name is Ronnie, the surname is Muratset from the ANC. And I want to rise to second the move as proposed by Honorable Lesoma. Thank you very much.
No, thank you for formalizing things. This is the formal meeting of the Ad Hoc Committee. So we have a seconder, and then any opposition to that proposal? Honorable Melder, I see your hand. Honorable Dr. Melder?
I guess you are putting it to the vote. Yes, thank you, Chairperson. I guess you are putting it to the vote. The Freedom Front Plus will vote against.
No, I want to first find out if is there any counter motion? There's no counter motion. Yeah, I'll put it to the vote now because there's no counter.
In front of us, and we must say yes or no.
Oh, I see Mapula there, Honorable Breitenbach.
Good morning, Chair. Good morning, colleagues. Thank you. If we're voting, then the Democratic Alliance votes against.
Okay, DA against, and then Honorable Dr. Melder.
Yes, Chairperson, the Freedom Front Plus will vote against this proposal.
Okay, Honorable Shibambo.
Yeah, the EFF votes against a proposal that expropriation of land must be subject to compensation. Those who are for the proposal, who are they?
Six of the ANC voting members, Chair, as per the alternate register. Thank you. Because
Okay,
we are 7, so we are actually 8. So that means that I have to mention the numbers.
So the proposal is carried. Thank you. Advocate Haley?
Yes, Chair.
Can we
Chairperson,
proceed?
point of order.
Yes.
Chairperson.
Yes, proceed.
I hear what the Honourable. Yes, thank you. I hear what the Honourable Suma is saying. There may be more members of any party present, but in fact only 6 in terms of the rules of the House, in terms of the composition of a committee can vote. So it can never be more than 6 from the ANC side.
No, you didn't hear me, Honorable, through you, Chair. I said we are more than 6, but 6 members, voting members. I did table them. I'll read you the names again for the purpose of just making sure that it's explicit to what I've said.
Please don't correct mine. Please don't.
Yeah,
I think you've done it very well.
Yeah, thank you.
No,
the Chair will give guidance.
No, I think we shouldn't create a problem where there's none. There's nothing wrong in repeating for record purposes. Maybe he had not heard that. Proceed, Honorable Suma. Read that.
It's just, yeah, let me just leave the other things. Chair, one ANC has got 6 voting members, and 2 alternate have the right of voting. So in the absence of any member, which I'll read it for you for the purpose of this, it's Honorable Professor Motsecha, Honorable Lesoma, Honorable Matlatsi, Honorable Kumete, Honorable Murasehla, Honorable Bongo. Then let me explain. Bongo has got a standing apology, Chair. Let's leave that one. So Honorable Nolita Tobongwana then comes up in terms of the voting. Those are 6 members. Then and then the other ones who are not voting alternates is Honorable Nkosi Mandela. And they are all here, and also the non-voting one, which is Honorable Kaba, all who are here. So 6 voting members are presented as a number as the ANC that votes in support of the ANC proposal. Thank you very much.
Thank you, Honorable Suma. Advocate Heli. Sorry, Honorable Shibambo, you want to say something? Honorable Shibambo?
Must be delayed.
No, we've already voted against
okay, no, thank you.
the reactionary position of the ANC.
Honorable Shibambo, you
Honorable Shibambo must be ordered.
Don't provoke us unnecessarily.
No, let the chair deal with that. I'm just.
And then what will you do when you're provoked unnecessarily?
No. You know, you must accept humor as well. Maybe it does that as part of humor to keep us alive. Honorable Advocate Ellie.
Thank you, Chair. I will move on to the next clause, which is clause C. There are 2 proposals, 3 proposals, one being from the ANC and Al-Jama, and then another proposal from the EFF. The proposal by the ANC and Al-Jama is exactly as it appeared in the bill as was advertised. Nothing has changed.
What are we voting for here?
And the EFF has proposed the deletion of subsection 3. Can I pause for the committee to deliberate and decide?
Okay, the floor is open, Honorable Shibambo.
Chair, it's not C, it's subsection 3 of section 25. It's not C. What you are being given here.
It is subsection 3, but C is as it is amended in the bill. So when I mentioned
what we're dealing with here, our proposal is that the entirety of subsection 3 has to be deleted because it was now determining the amounts and the conditions and circumstances upon which compensation had to be paid. And we are of a firm view that that subsection, when we then deal with expropriation without compensation, which we have proposed in subsection 2, subsection 3 must altogether fall. That is our firm proposal, that we delete the entirety of subsection 3. That is the proposal that.
Okay, Dr. Luttrell.
Thank you, Chairperson. As a consequential decision in terms of what our position was in terms of 2B, we also do not support the ANC and Al-Jama proposal in C, and we also do not support the EF proposal that subsection 3 be deleted. Thank you.
Okay, any other, Dr. Mulder?
Chairperson, I'm not sure in terms of the process. Just now when the ANC did put their proposal in the previous occasion, you did ask for a seconder, but you did not now ask for a seconder when Mr. Shivambu did put the proposal by the EFF.
You are correct. Honorable Suma made the proposal. Is there anyone from the ANC seconding that? ANC, any second of the proposal? ANC, Honorable Mahlatsi.
Chair, maybe I'm misunderstanding what yourself and Honorable Melda are indicating, because I thought Honorable Murathatla seconded, unless we're speaking about.
No, he did on the previous occasion. We're dealing with
Okay.
another section now.
All right. Let me second the motion as presented by Honorable Zoma, Chair.
Thank you very much. Is IFP here? Advocate Bonani? Advocate Ramano?
Chairperson, the IFP is not in the meeting.
Is not in the meeting, okay. Thank you. So any counter motion to the ANC is Honorable Shibambo. Who seconds the counter motion? Any seconder to the counter motion of Honorable Shibambo? None. That means the ANC proposal is carried. Honorable Shibambo, do you want to say something? Is that an old hand?
No, Chair. Like we're not
Okay.
there. But we still stand firm that we must delete subsection 3.
Yes.
Okay. No. We have noted that, but the ANC proposal is carried by the majority. Can we proceed? Advocate Haley?
Chairperson.
Sorry, Chairperson. I don't want to be technical. Just on the previous one, before we proceed, I just made a point with regard to the seconder. So you're putting the ANC's proposal, and I just want to make it clear that the Freedom Front Plus also votes against the ANC's proposal. Thank you.
Okay, thank you. Noted. Advocate Haley?
Thank you, Chairperson. The next clause within the bill that we'll be dealing with is clause D, which is an insertion after subsection 3.
Wow, it's open now.
Can I continue?
Yes, but there's some noise. I don't know where it comes from. Can people mute, please? Please mute to help us to proceed smoothly.
So the next. Yeah.
Advocate Gwebu? Advocate Gwebu?
Yes, Chair, I'm here. It was Honorable Murathatla, he is muted, Chair.
Okay, thank you very much. Proceed, Advocate Haley.
So the next amendment is an insertion after subsection 3 of a new clause, section 3A. It is, as the ANC has suggested, it is for the removal of the word court, and 3A will now read as, for the furtherance of land reform, national legislation must, subject to subsection 2 and 3, set out circumstances where the amount of compensation is known. Al-Jamaa has also made a proposal, and the Al-Jamaa proposal is similar, but they've also added 2 subsections to their proposal. They had originally suggested a paragraph 3A and a paragraph 3B, but as the concepts are the same, we suggested that it'd rather be done in 2 subparagraphs to 3A. We've reworded the proposal in order to make sense of what was proposed. The Al-Jamaa incorrectly had made mention of subcommittees and subcommittees passing legislation, and we amended that to read that the House would pass legislation. Furthermore, the provisions need to be made clear regarding voting, and we made provisions for that, and we included the NCOP as well. So these are the 2 proposals with regards to the new subsection 3A, and I'll pause for the committee to deliberate and vote.
Any seconder?
May I, Chair, formally move for the adoption of the ANC proposal as presented? Thank you very much.
Any seconder to Honorable Suma's motion? Honorable Murathatla?
Chairperson, my name is Ronnie Sene Muratsetla from the African National Congress. I rise in this portfolio committee to support and second the move as presented by Honorable Lesoma Bayranki.
Thank you. Any counter motion to the ANC motion? Honorable Shibambo?
No, look, we are voting against that because in any way our proposal is that the entire subsection should be deleted.
Any seconder to the EFF proposal? No seconder. Honorable Dr. Mulder?
I'm just making you aware that we are voting against the proposal of the ANC. Thank you, Chairperson.
Thank you. Honorable Dr. Lottery?
Thank you, Chairperson. The DA, all 2 members vote against the ANC proposal.
Thank you. ANC members, motion is carried. Can we take the proposal, the formal motion from Al-Jama? Al-Jama, are you here? Advocate Gwebu, is Al-Jama here?
Chairperson, they were here, but I think maybe he logged out at some point because, well, he's there. Is it Honorable Hanif Hendricks, right?
Yes.
Yes, he's still here in the platform, Chairperson.
Honorable Hendricks? Honorable Hendricks?
Honorable Chair, I have problems, so my video is not on. And I had some sound problems, which I think I've sorted out now. If the question can just be repeated, Honorable Chair, I'll appreciate it.
No, we wanted you to formally move your proposal and get a seconder.
I'd like to formally move Honorable the proposal as stated. Thank you very much.
Any seconder to Al-Jamab's proposal? You are the only member.
That's correct.
So there's no seconder.
Chairperson, just to correct, Al-Jama is not a voting member, Chairperson. According to, is a non-voting member, according to our record. Yes.
Non-voting member. So,
yes, Honorable Chair, we do have 2 members on the committee that represents us. And so the smaller parties, the 7 smaller parties, are represented by 2 members on the committee. So it's not correct to say that we don't have voting powers. Our voting powers is we've got proxies in terms of the rules of Parliament. So it's not correct to say that Al-Jama doesn't have any voting powers.
Advocate Gwebu, what is the basis for your conclusion that they don't have the right to vote? Advocate Gwebu?
Yes, I'm here, Chair. From the 18th that we received, Chairperson, there was a list of voting and non-voting members, like as it was stated. So Al-Jama is a member, but with classified as a non-voting.
But anyway, the motion has no seconder now. Let's assume, for argument's sake, that he has the right to make a proposal, but he doesn't have a seconder.
Okay.
And that would mean that the ANC proposal is carried.
Okay.
Okay. Honorable Shibambo?
No, just to give a contextual clarity on how smaller parties vote is that they are grouped into an equivalent of 2 votes, and they've got representatives of those people who must vote on their behalf. So if they disagree amongst themselves, there is no mechanism to determine whose side do they vote on in terms of what happens. So even if Al Jama wants to vote for or against and everything else, it's meaningless if they've not canvassed that with the smaller parties that represent them in this platform. I think it is handled differently in a different committee, but here they have to live with whoever they've mandated to cast a vote on their behalf that is going to cast according to what they believe should be the way forward.
Thank you very much, Honorable Shibambu. I see Honorable Dr. Mulder and then Honorable Hendricks. Can you take those?
Yes, Chairperson. No, the idea of parties being grouped together and then have two members is something that was part of the fourth Parliament before 2019. In terms of the current process and in terms of the ATC, the EFF and the IFP represent themselves in this committee and have voting rights, but that does not mean that other parties cannot participate, and that's why Mr. Hendricks has participated in his own right throughout the process and has made proposals in his own right. So your ruling is technically correct, and I think we could move on.
Okay, thank you. Honorable Hendrickson?
I agree that your ruling is correct, Honorable Chair. It is a pity that the two members representing smaller parties are not consulting with us, and that makes a mockery of this particular arrangement, that they have the vote on our behalf, and yet they don't have the decency and the courtesy to consult with the parties that they represent. But we respect your position, Honorable Chair.
Thank you, honorable members, and the ANC proposal is carried.
Chairperson, I've raised my hand again, please.
Yes, proceed.
Yes, maybe Mr. Hendrickson did not listen to what I've said. He's absolutely 100% wrong at this stage. We are not here to represent other parties. We represent ourselves in terms of the ATC, and Mr. Hendrickson represented himself. That's why he participated throughout the process. He made even proposals on his own behalf. So unfortunately he's wrong.
Okay, no, fine. I think we are helping one another understand this position. Because yes, proceed. Yes.
There is nothing wrong with what Al-Jama Hendrickson has said. The smaller parties can individually cast their own vote. That is a fact. So in terms of the ATC list, that is why the support staff is saying that they can't vote because they are not the mandated people who have been ATC as members with voting rights in the committee. Of course, they can fully participate, they can move motions, they can make submissions, but when it comes to casting a vote, they can't vote unless if they've consolidated that vote with the smaller parties that have been grouped into two votes. That is a fact.
But the situation now is not compromised because the motion has no seconder and the ANC motion has been carried. So let's leave matters there and move on to the next, to Advocate Haley.
Agreed, Chair.
Advocate Haley.
Thank you, Chairperson. The next clause in the bill is clause E, which is an insertion after subsection 4 of section 25. There are three proposals made by three different parties. The first proposal is by the ANC that a new subsection be included in section 25, which is the land is the common heritage of all citizens. The state must safeguard for future generations. The second proposal is that by Al-Jama, and that is a new subsection 4A, which states the Waqf land is an endowment solely offered to Allah that must be safeguarded for future generations. And B, for the purposes of this section, Waqf land means a sacred endowment of the property to be held in trust for charitable purposes in such a manner that it should benefit the current generation as well as the subsequent generations. The Al-Jama proposal to include Waqf land, the definition of Waqf literally means to stop or contain in Arabic, and legally the term has been employed in Muslim communities to mean a religious endowment. That is a sacred endowment of property, such as a school or a hospital held in trust. It is essential to use for charitable purposes in such a manner that it should benefit the current generation as well as subsequent generations. We need to caution that the Constitution tries to stay clear of religious terminology. And this
On a point of order, Chair.
Yes.
We had said that the legal office must read what is in the text, must not give us argument. They will do that later if they want to do so. We're just choosing which sections do we prefer now. They must not debate for or against any of the submissions. They're just reading. You're just reading. Please read and allow us to debate, please.
Advocate Haley, I thought this was agreed. You seem to.
Okay.
Yes.
Yes, I did understand that I was not supposed to speak to procedural matters on what should be advertised and what shouldn't be advertised. But speaking to the content of the bill, it is within, I think it would be remiss of legal services to not advise the committee correctly on what is required of legislation and dealing with the intricacies of drafting legislation. We're not going to comment on the procedural aspects. That can be left for after we decide on what should remain in the bill and what should not remain in the bill. But I think it would be remiss and it would be not within my duty to set out what is required of drafting legislation.
Thank you. Let's hear Honorable Hendrickson, Honorable Kawa on that question. Honorable Hendrickson.
Thank you very much, Honorable Chair. Honorable Chair, we're very grateful that this matter is being considered. Religious land cuts across different faiths and cultural communities, and we just felt that, you know, the state shouldn't be in control of that land, but that the status quo should largely remain. And the legal advisor did point out how that is being addressed. So we have put a proposal, and it is up to the committee to decide whether they will respect sacred land, religious land. And in this particular case, because we represent our constituency, we cannot speak for other constituencies. We are referring to Waqf land, that in the event that there is a decision that all land must be owned by the state, which is a position or a respected position of the EFF. We just felt that if it comes to that, then Waqf land and religious land and sacred lands must be excluded because of strong positions of faith.
Thank you. Honorable Kawa.
Yes, Chair. No, legal advisor, we are trying to protect you, not to provoke the discussion that is not necessary at this stage. And I think it's more to try and protect you. Just present, the parties have discussed this thing, they know where they stand, and I don't think we are now voting. We'll then take the discussion at a later, a political discussion at a later stage. It's just for your protection. Thanks.
I think, Advocate Haley, I agree that this is nothing against your protection. Because you see, for instance, our state is a secular state, and we can't put in the constitution religious positions because now we'll have to say, what are the Catholics saying? What are the Hindus saying? What are the Muslims saying? It's going to create problems. I think let's stick to the proposals, we vote on them, and then we proceed. Now proceed, but stay away from the opinions.
Thank you, Chairperson. The next insertion is a proposal by the EFF. It is an insertion into after subsection 4. It is 4A. The way it was proposed by the EFF was that it should be included in subsection 4 as a new paragraph C. And as subsection 4 has paragraph A and B, this would then be paragraph C. However, drafting conventions do not allow for this, so we have created a new paragraph for the proposal, which is paragraph 4A, and it reads, land is a natural resource and the common heritage which belongs to all the people, belongs to the people as a whole under the custodianship of the democratic state. These are the three proposals, and we will pause for the committee to decide.
Honorable Hendrickson.
Honorable Chair, we note your position that this is a secular state and we can have a political debate about it, because I don't know of any political party that wasn't formed in the church, either formed in a church or in a mosque. That's a foundation of, even the Communist Party was formed in the church. But let's not go into that particular debate. That is your position and we respect your position. So we would like to propose that work of land, just to summarize the proposal, must not be in the custody of the state.
Okay, any seconder? No seconder. And then the EFF position, can it be formally put forward?
No, thanks, Chair. We are firmly proposing as the EFF that we should include in the Constitution that land is a natural resource and a common heritage which belongs to the people as a whole under the custodianship of the democratic state. We think that that subsection should firmly establish custodianship of all of South Africa's land. That is our firm proposal. And you will see later on in terms of what we say in subsection 5, current subsection 5, that there should be necessary legislation that will deal with the issue of custodianship. So our firm proposal is that all of South Africa's land must be under the custodianship of the state for equal redistribution. The Freedom Charter calls it redivision of all land. Ourselves were saying, let us have it under the custodianship of the state for equal redistribution. That is firmly what we are articulating, consistent with the founding manifesto of the Economic Freedom Fighters adopted on the 26th of July 2013. That is our firm perspective, and we're not shifting on that.
Thank you very much. Any seconder to the EFF proposal? Honorable Lesuma, are you seconding the EFF proposal?
No, Chair, at one stage, definitely no. At one stage, the system kicked me out. I wanted to move for formal the AC one. When you call it, then I'll do that. Thank you.
Oh, okay. So there's no seconder for Al Jama proposal and for EFF proposal. Can we call on the ANC to make their proposal?
Thank you very much, Honorable Chair. May I do that? And I move for the committee that adopts the proposal of the ANC as presented. Thank you very much.
Any seconder for the ANC proposal? Honorable Murwasetla.
Chairperson Ronnie Murwasetla, I rise here to second the move as presented by the African National Congress through Honorable Lesuma. Thank you.
Thank you. That means that the ANC motion is carried.
Yes, but Chairperson. Sorry, Chairperson.
Yes.
I just want to bring to your attention that the FF Plus votes against the ANC proposal. Thank you.
Thank you. That's noted. Honorable Dr. Lotrich.
Thank you, Chair. Yes, I raise my hand to also have the DA's, well, it be noted that we do not support the inclusion of this proposal.
Okay, thanks very much. I think we are proceeding very, very well. Advocate Helen, can we move on?
Thank you, Chair. We will now be moving on to clause E of the bill, clause F of the bill, which is the amendment of subsection 5 of section 25 of the Constitution. There are two proposals made, one by the ANC and Al Jama, and one by the EFF. The ANC proposal is to include the following into subsection 5 of the Constitution. The state must take reasonable legislative and other measures within its available resources to foster conditions which enable state custodianship of certain land in order for citizens to gain access to land on an equitable basis. The second proposal is that of the EFF, which states that subsection 5 should be amended to state that the state must take reasonable legislative and other measures, and then to delete within its available resources to foster conditions, and then which enable and include state custodianship and for the citizens to gain access to land on an equitable basis. With regards to the EFF proposal, drafting conventions do not allow for us to shift the subsection paragraphs in the existing acts. We thus have to draft around the existing subsections. Hence the change in numbering from what the EFF proposed, which was that the amendment should be made to subsection 4. But it will remain as an amendment to subsection 5, even if we were to delete subsection 3. The content is, however, the same. These are the two proposals, Chairperson, and I will pause now for the members to vote thereon.
Thank you. Honorable Lesuma.
Thank you very much, Honorable Chair. I move for the adoption of the ANC proposal as presented. Thank you very much, Chair.
Any Honorable Masazu?
Chairperson, I stand to second the motion by Honorable Sama on behalf of the African National Congress.
Thank you. Honorable Murosatla, there's no thirding. You want to third?
No, Prof, I'm covered. I'm covered by the two ladies.
Okay.
The two honorable ladies. Thank you.
Thank you very much for your understanding. Honorable, is there any counter motion to the ANC proposal?
Yes,
Honorable
Chair.
Bambo?
Yeah,
Yes.
our counter motion says what we had said in the subsection 4 inserted C, to say that the state must take reasonable legislative and other measures within its available resources to foster conditions which enable state custodianship and for citizens to gain access to land on an equitable basis. So that is our proposal. And of course, let me read it again so that we then remove the ones that is bracketed. The state must take reasonable legislative and other measures which enable state custodianship and for citizens to gain access to land on an equitable basis. That is how we say what currently appears as subsection 5 must read in that particular format. It will of course be subsection 4 because we had proposed the deletion of subsection 3 of the Constitution.
How many members do you have, voting members?
One. Voting is one.
Now, do you have any seconder for this proposal? You don't have a seconder. Al Jama, what is your proposal?
Our proposal is in line with the ANC proposal, and we accordingly request our two representatives of the smaller parties to support that proposal.
Thank you, Dr. Melder. And Honorable.
Yes, thank you, Chairperson. I'm not going to repeat for the sake of Mr. Hendricks. At some stage, you'll understand what I've said in the past. The Freedom Front Plus will vote against the proposal by the ANC. Thank you.
Dr. Ludwig.
Thank you, Chairperson. The DA also votes against the ANC proposal.
Okay. I think the ANC proposal is the only one that has been seconded, and therefore it is carried by the majority ANC voting members. Advocate Haley, ANC motion is carried. Can we move on?
Yes, Chairperson. We will now move on to clause G, which is the substitution of section 7 or the amendment of subsection 7. And this is one proposal by the EFF, which is to delete after 1913. So the subsection 7 will read, a person or community dispossessed of property as a result of past racial discriminatory laws or practices is entitled, to the extent provided by an act of parliament, either to restitution of that property or to equitable redress. That is the only proposal, and I will now hand over back to you, Chairperson.
Before we put this matter to a vote, I'm just wondering whether, because this issue also came from the public hearings, and in our discussions, we never looked at the possible consequences of the cutoff date. And now the authorities, experts who write on this thing, say that this cutoff date was just a compromise that did not look at the implications. I want to be guided by the meetings, whether we should not just agree to include this proposal so that we really go back to the people, because this thing can create serious challenges to us. But I don't have a position. I know that we have agreed that we are not debating, but I'm just raising this issue because it may come back to bite us if we just deal with it in terms of numbers. Let's hear Honorable Melder.
Yes, Honourable Chairperson, I'm a bit confused now because I have heard on numerous occasions that the ruling party, who has the majority in this committee, has made it clear that they do not propose any amendment to this specific section of Section 25. What you are now saying is a different position from that position, so I don't know if you want time out to caucus, but it makes it a bit unsure what the position now is, and there's no proposal in front of us at this stage from the ANC in any case, so I'm not sure where we are going.
No, I just wanted us to be clear as we move forward, because this is an EFF proposal, I'm saying, which also came from the public hearings. And I personally looked at expert opinion on this thing. It can come back to bite us. So I want us to be sure that if we move forward and we just reject it, that we do it consciously, and when it comes back to bite us, we should have anticipated that. But let me hear Dr. Lotrich, and then hear Dr. Honorable Shibambo, and then go back to Mr. Honorable Kaba.
Chairperson, yes, I find this also very strange that you would make such a proposal, because up to now we have worked purely on what the different parties have proposed, and where it is also seconded. So I agree with the Honourable Mulder that in all our past meetings, the ANC were quite vocal about not supporting this. You refer to expert opinion. This committee has not been appraised of the expert opinion on this particular matter. It is not contained in any of the ANC documents. So, Chairperson, I would purely on a procedural route be totally against that. This is now basically what I'm actually saying is that you are now seconding the EFF proposal. Is that correct?
No, I'm not speaking on behalf of the ANC. I'm not seconding the EFF proposal. I was just placing on record what happened before, but I'm going to follow the procedure. The procedure is that we're going to vote on all these things, but I just first wanted to hear if there are any fresh thinking on the matter. I'm not representing ANC, I'm not representing EFF, I'm just chairing the meeting. Honorable Shibambo.
No, thanks, Chair. We firmly submit that that clause must read as follows: that a person or community dispossessed of property as a result of past racially discriminatory laws or practices is entitled, to the extent provided for by an act of parliament, either to restitution of that property or to equitable redress. That is our firm proposal. And we must take note that the 19th of June 1913 is the day the apartheid whites-only government enacted the Natives Land Act, which basically allocated 7% of South Africa's land surface to indigenous people who had been dispossessed. There is proper demonstration of the land dispossession that was conducted by the barbaric colonial settlers throughout history, even prior this date, which is in the Constitution now. And to say that only land that was dispossessed post this date is problematic because it doesn't even scratch the surface of the land reform program that has to be looked into. And the legislation can deal with all those aspects of upon which criteria and upon which means do you restitute land and for what particular purpose. So legislation will cover all of those issues that are your concerns and fears. But to include that date there is to legitimate the apartheid dispossession, which was now formalized on 19th of June 1913 by the colonial whites-only government, which got to take the land from our people. To retain that part of the constitution intact is just playing into the hands of the colonial settlers. We're just pleasing them, and it will never serve you any purpose. And so we firmly suggest that that date must fall, and then legislation will deal with issues of restitution as an instrument of land reform and how to utilize that much more meaningfully in a way that will give access to land for all our people irrespective of race. That is our firm proposal, Chair.
Okay, I noted the fact that the ANC said they are not changing anything there, but I will give Honorable Lesuma Nkawa the right to say something before we go to vote.
Okay. I hope you're not asking us to comment on the EFF proposals.
No, I'm asking you to say what you want to say.
The procedure is that parties present their proposals and we vote. We'll take the discussion at the end. Can you follow the procedure, Chair?
No, I said that I'm giving you an opportunity in case your position has changed. You say so. If it hasn't changed, you say so, and then we follow the procedure thereafter.
Chair, can I comment on that? No, for now, there's an EFF proposal on the table. We'll then discuss it, that all these points when we take the discussion towards the end, Chair.
Okay, no, that's fine. Honorable...
when we get to political discussion.
Okay. Honorable Lesuma.
Thank you, Honorable Chair. ANC doesn't have any amendment in respect to what is tabled now.
Okay.
Probably just to be fair on you, Chair, because we respect also because you are entitled to persuade parties also to think otherwise, that precisely on the score that we are dealing with a whole section of Section 25, so that we are able to advertise that thereafter we'll come back after 3 weeks and engage on these issues. So we don't have for now, Chair. Thank you very much.
Okay, thanks. Honorable Hendrickson.
Honorable Chair, we should obviously support the ANC position. There's no change. We do not agree with the EFF that, for example, the Khoi and the San, whose land was dispossessed wrongfully, should not be considered. And we feel that the way the legislation stands now, there is an opportunity for the Khoi and San and maybe other communities also to get restitution or reparations. So that is our position. We don't support the EFF in excluding the Khoi and the San.
Okay, then the three hands that I see, I guess, are old hands. And then we can proceed to the formal presentation of the motion. EFF has presented, but they don't have a seconder. And then Honorable Hendrikse, you have not made any proposal. So
our proposal is in line with the ANC's position.
Or that the subsection 7 should stay as is. Is that what you are saying?
That's correct, Honorable Chair.
Okay, thank you. So we are ANC, can you formally propose that you want the subsection 7 to stay, and we get a second?
Chair, I think present the EFF proposal. Just check if it does have support, and then leave it at that.
No, it's not seconded, so I can't present.
So we then we proceed, Chair. It means it's not. Yeah.
Can I move forward, Chair? Can I proceed? Chair, I think you're muted.
The chair is muted.
No, thank you. No, I'm no longer muted.
Yeah,
Thank you.
yeah.
Yeah.
So we will proceed now to the final amendment, which is clause H, and it is an amendment to subsection 9 of section 25 of the Constitution. There are two proposals, the first being from Al-Jama, and that is Parliament must enact the legislation referred to in subsection 6, which legislation should include provisions for reparations. The proposal by Al-Jama was that the legislation should not exclude reparations, and we changed this to should include provisions for reparations. This renders the same meaning as proposed by Al-Jama, but it is more clearer, as you often draft in the positive. The second proposal is for the amendment of subsection 9, and this is proposed by the EFF, and that's to say Parliament must enact legislation referred to in and for the deletion of subsection 6, and then for the inclusion of this section. So the EFF has proposed that that subsection 9 should read as follows: Parliament must enact the legislation referred to in referred to it in this section. Referred to in the section, yes. So these are the two proposals, Chairperson and members, and I will wait for the committee to decide on what to proceed with.
Honorable Shibambo. Thank you, Honorable Helen. Honorable Shibambo.
No, thanks, Chair. So the essence of the EFF's proposal is based on the fact that in all subsections, the Constitution is already giving a directive of laws that have to be passed to realize such. So in subsection 1, for instance, it says that no property may be deprived except in laws of general application. So there has to be legislation on deprivation. And then in subsection 2, where we speak about expropriation, there has to be legislation on expropriation in terms of what do we do in terms of expropriation without compensation, as we are proposing, in terms of what should happen. And in terms of our insertion now on custodianship, there has to be legislation on custodianship. That is why we say in subsection 5 as well, that there has to be proper legislative measures to realize custodianship of all land. But also in the subsection which has got a date, the subsection 7 or 8, which talks about the restitution, there has to be adequate legislation on restitution. That is what the entire subsection 25 deals with. That is why we then say that as an exit point, if all of these are considered in the final amendment, you need to say that Parliament must enact legislation referred to in the entire section 25, not just in subsection 6, as is phrased in the current constitution and the proposed amendments thereof. So that is basically the essence of the submissions that we are making as the EFF to conclude how section 25 must look like. Thanks.
Honorable Shibambu, there is the Land Restitution Act 22 of 1994. Are you saying that you want another one on top of this one, or you want an amendment of this? What are you saying?
Okay, so in all these aspects, right, there has to be legislation on deprivation. There is no legislation on deprivation currently in terms of what happens and subsection
No. I know
those
that.
aspects. So now, in terms of restitution, if it's provided for there, it's okay. It's okay if it is provided for there in terms of what happens. But also, if you read into the current subsection 7, it already states that those who have been dispossessed of land post June 1913 should be, according to law, according to legislation, be entitled or eligible for restitution or equitable redress. So that is just a repetition of what is there in the other subsections that have dealt with areas that require specific attention, which is expropriation, deprivation, expropriation, and the issue of restitution. So those are the 4 aspects which would then say that Parliament must be given a constitutional obligation to have adequate legislation on all those 4 pillars that we.
Thank you for the clarity. Any seconder to the EFF proposal? Honorable Hendricks, are you seconding?
No, Honorable Chair. We have our own proposal.
Okay, put it.
I'd like to thank the legal advisors for making that change. We're quite happy that that is a more appropriate position. We would then like to propose, and Honorable Chair, one tries and lobbies and persuades and get other parties to support your proposal. And while we expect the ANC to support this proposal, we also are represented, and I disagree with the Honorable Mulder, that if you represent 6 parties, that representative needs to debate these issues with those parties you represent, and don't put forward the position of the Freedom Front, for example, because if they had a right to make their own position, then the rules of Parliament would have allowed it. But now they are representing smaller parties, and they should consult us. So we would like the Freedom Front Plus to take into account that one of the parties that they represent has put forward the proposal, and we're lobbying and we're asking them also to support our proposal. And we hope that the ANC will also do the right thing and support this proposal. I don't want to go into the merits of calling for reparations. We all know about it. You mentioned it earlier on about the harm that has been done several times, and it is as if there is no harm being done. So certainly, if harm has been done, reparations has to be paid. And he's not only taking the land back, but those who benefited from him for decades, they need to pay something. Thank you, Honorable Chair.
Hello, Dr. Melda.
Yes, thank you, Chairperson. I'm really not going to repeat what I've explained on
No,
two.
you shouldn't.
I raised my hand before Mr. Hendricks then gave some clarity in terms of what he means with reparations. If I understand him correctly, so the current owners of land in terms of his proposal must pay reparations. But he cleared that, but I raised my hand before he said that. Thank you.
Oh, thank you. Honorable Shibambo, is that an old hand? Any seconder for Al Jama's position? So the motion by Al Jama and by EFF fall away because there's no seconder. ANC, can you put your position, motion?
Chairperson, I move that this meeting adopts Section 25 amendment for publication as presented and agreed by the meeting in terms of inserting what ANC has suggested as well, but the whole section from 1 up to 9. Thank you very much.
Any seconder that's from the ANC, Honorable Muslim?
Can I come in?
Yes.
Can I come in?
Murasata is first. Okay, you come in.
No, I just want to.
Yeah, proceed.
Yes, correct. What Honorable Maina is saying is that the amendments now as proposed and supported, the ANC is proposing that they be gazetted for public, for written comments. She said that and then we give public 3 weeks to make their submission, written submission. That was the proposal that Honorable Sima was putting forward.
Thank you very much for putting it loud and clear. Thank you, Honorable.
No, but you have amplified the motion by Comrade Suma. Now I need a seconder of a motion, including your amplification. Who is the seconder? Honorable Murasata.
Chairperson, thank you very much. After listening very carefully to the move by the African National Congress through Honorable Lesoma, we rise here to support, as we second, that the positions as amended be taken for whatever public representations.
Chair, you are muted. We can't hear you, Chair.
No, thank you, Honorable Kawa. I see the hands of Honorable Shibambo, Hendricks, and Melda. I don't know if they are old or new hands, but if they are new, I'll ask them, Honorable Shibambo, to proceed, Honorable Melda to follow.
No, Chair, we officially reject the proposed amendments of the ANC to Section 25. We believe strongly that this is a betrayal of their own resolution and it's a betrayal of the landless people of South Africa, particularly the indigenous Africans who were dispossessed of their land through colonialism. So we reject with contempt, and we're going to vote against the motion and the amendments as proposed by the ANC because they outrightly will never take back the land to give to our people on an equitable basis. So we stand opposed to the proposals of the ANC.
Honorable Dr. Melda.
Yes, thank you, Chairperson. I think that all the parties have made their position clear as we went through the process and as we have voted, so I don't think it's necessary to restate those positions. I've raised my hand. I just need clarity in terms of the process now, because Honorable Suma has made a proposal that we now publish in the Gazette this amended version that the committee has dealt with. And I just need clarity in terms of the advice that they've received from legal services. There are some of these amendments that we have now adopted by the committee with the majority, that in terms of the interpretation by legal services, that we will have to approach the National Assembly also to get permission to do that, to extend, because it extends the scope. And what I also would like to ask is, in terms of the process, will they only be calling for written submissions, or do we indicate to the public that if somebody would like to make oral representation, they should be allowed? I think it's important that the process should be absolutely clear and that we know what the public is expected to do. Thank you.
Thank you, Honorable Melda. But before we get to that, can I just say that the ANC proposal is carried, that we advertise what has been agreed. And then the second stage is what Dr. Melda raises as to what is the way forward. Honorable Suma, are you going to do that, or legal services? Who is going to do that? Honorable Suma?
Thank you very much, Chairperson. One Chair, the legal services says that we must go back to the House. And what I would like to put forward, Chair, is that when we were constituted, we were given a mandate to amend Section 25. There was no prescriptive in terms of the clauses. In our own wisdom, because we couldn't agree and there was no time to agree to what text has to go out for public participation processes, we agreed on a compromise that was presented by the Parliamentary Legal Services. But we are very clear in our minds that we are supposed, and we were going to look at the whole Section 25 from 1 up to 9. When we reconstituted, Chair, we were given again a mandate that we incorporate all the work, or we consider all the work that was done by the 5th Parliament through CRC committee, which mandated us. Because of time, they couldn't conclude that that's the party that we're dealing with in this 6th Parliament. So for legal services, Chair, to come and tell us that we must go back to the House, fully aware that House said we must amend Section 25, not the sub-clauses, but also fully aware that what went out was a compromise. Even that compromise, after the 3 public participation processes, which is 1 written submission, public hearings, and oral submissions, all people who have made submissions spoke to the whole Section 25. And for me, it is logical that even ourselves as various political parties, when we're inputting, even engaging now, from the last past few meetings that we're engaging at the Section 25, we were clear that we're not going to limit ourselves to what went out as a compromise. So that's the rationale, Chair, and I'm responding to it. If then there is anything that is wrong about that, the House will condone the committee after we've concluded the whole process. Thank you very much, Chair.
Thank you, Honorable Suma, Honorable Kama, and Honorable Shibambo.
Thank you so much. Honorable Suma has put it so well. I just want to remind you, Chair, that even the legal opinion was not definite on that issue. All what it said is that to err on the side of caution, right? But we note that. But what we are suggesting that this bill, our suggestion that this bill must be publication if anything, we are substantially complying with the object or the purpose of that requirement. I think the requirement was that we must consider, sending this back to the public. We are proposing that it must be for 3 weeks, and also proposing that it must be for written submission. And if for whatever reason, Parliament, that's what Honorable Mona is saying, if for whatever reason Parliament says, in actual fact, you should have come back to us before you went to public, and then Parliament will tell us that, then we'll cross the bridge when we get to it. But we would have complied with we would have made a substantive actually compliance. I think that's a point that Honorable Mona is raising. And so let's do that. There's no Parliament sitting. It will only sit sometime in August. So if we are wrong, Parliament will tell us that we are wrong, and also tell us how we can that situation can be remedied. Let's leave it to Parliament. Ours is to do our job. Thank you so much.
Thank you, Honorable Honorable Shibambu.
No, Chair, the correct legislative process in Parliament is that you publish a bill, these public hearings, these submissions, written and oral. Committee deliberates and must table that back to the House, not republished.
So you are breaking it.
Okay.
He is breaking. I don't know if it's on my side only, Chair.
It's on your side.
I think it's on your side. It's on your side, but he will repeat. Can you repeat?
I'm saying the proper legislative process of Parliament is such that you first publish a bill, call for written submissions, oral submissions, conduct public hearings, and then come to deliberate and finalize as a committee. And once you have finalized that, you then go and table a report in Parliament to say that this is what we have reached as the conclusions after having taken into consideration all the submissions that came from the public hearings, the oral submissions, and written submissions, and taking into considerations what we thought are legitimate additions to a legislation, to a bill. You don't republish that bill before you take it back to Parliament. It will be the first if you do that now, in terms of the process that you're suggesting. So the manner in which you're suggesting it now is unprocedural. It's inconsistent with how legislation is processed in Parliament. So we don't agree with your amendments and the manner in which the bill looks like now, but it is unprocedural to want to republish it again because already it has been published. If you want to publish it again, you are then you're opening up floodgates for all sorts of submissions, which must be inclusive of oral submissions and even public hearings in some instances. So to republish it is unprocedural. It's decisively unprocedural in terms of how legislation is processed in Parliament.
Honorable Mahlatsi.
Thank you very much, Chairperson. I think both Honorable Lesoma and Honorable Aba have explicitly put our understanding as African National Congress. But I think it is important because as comrades or honorable members of the EFF are making their own input, they must just leave it to their own issues, because African National Congress is quite resolute on expropriation of land without compensation, and they should further familiarize themselves with the contents of our own submission, precisely because there is no way where the ANC is actually deviating from its own policy positions, because if they have done so, they would have understood that subsection 3 speaks about expropriation of land where compensation is nil. Nil is equivalent to expropriation of land without compensation if they were not aware. However, we will not be subjected to dealing with issues in the manner in which they want them to be done. So we will not be manipulated as African National Congress. If we want to make submission, let's make submission on our own foot and will not be dragged into their own issues. They must just allow us to run the process the way we wish and see it fit as the African National Congress. Thank you very much, Chair.
Honorable members, we are at a stage where we are discussing where to from now, because we have agreed, we have voted on the subsections, and the ANC made a proposal which was seconded, so the ANC proposal stands. So the issue that we have to deal with now is where to from now. And Honorable Suma has led us there, supported by Honorable Kawa. But I think before we move, I want to allow legal services to comment on the way forward as proposed by the ANC.
Thank you, Chairperson. Honourable members, we had on a previous occasion presented a legal opinion to the committee on our position with regards to advertising, and also our position on with regards to extending our mandate or going back to the House to ask permission. I'm not going to go into detail with regards to that opinion, Chairperson. The committee members have all received the opinion. We can circulate it again. That opinion also contained an expressed view by the NA table. So, Chairperson, if the members would like me to go through that opinion again, or to set out the various rules that support our view, I can. But I think that what we should do is even ask perhaps the committee section to point out why they feel that we should not, why we should not go back and ask for permission, or whether we should not advertise. Our position stands and is unchanged, and we recommend asking for a second opinion if needs be.
Honorable Haley, you know, these matters have a political and an administrative dimension. As Honorable Suma correctly said, upon your advice, we adopted a compromise bill. When we adopted that compromise bill, not all political parties had made their input, but we accepted that compromise because we wanted to kickstart the process. So an Honorable Suma again correctly points out that the mandate, original mandate that we got from Parliament was with regard to amendment of the entire Section 25. That mandate did not limit us to one or two subsections. So why should we go back to the House? Because the House never limited our mandate. It is ourselves who limited the mandate because of the compromise. So I tend to agree with Honorable Suma and Kawa that actually there's nothing to go and seek from the House. The House gave us a blank check to deal with the Section 25. Do you agree with that?
I don't know if I agree with that. I can't really say. I mean, protocol has it that I have to stand by the opinion provided by my office. And that is the opinion of the office. And whether I agree with it or whether you have convinced me not to agree with it, it's I don't think I have the mandate to do that.
Okay. No, I want to say that we appreciate your opinion, but I think members feel, as I do, that we don't agree with that opinion, because that opinion is a technical opinion which doesn't take into account the political dynamics which led to the compromise position. So we can be bound to the compromise because that compromise even contradicts the original mandate that we got from the House itself. So there's no basis, in my view, for going back to the House to ask for something that they already have given us. Dr. Lothric?
Thank you, Chairperson. I just want to put on record that if you say that the committee doesn't agree with the legal opinion or whatever, that does not include the DA. Thank you.
Okay, fine. Dr. Mulder?
Yes, Chairperson. I guess it's the opinion of the EFF perhaps and the ANC, but we do not agree. We agree with the opinion. We think it's technically absolutely correct.
Okay, Honorable Kawa.
Okay, there is substantial compliance with the legal opinion. Let's go ahead. In actual fact, Honorable Shivambo was correct, but there is legal opinion. And what Honorable Moina Honorable Lesoma has presented is in compliance with the opinion substantially so. Let's go ahead. If Parliament says we're wrong, it will tell us then when we present our bill before it. And let's leave it at that. Thank you so much for now.
Now, there's an issue raised by Honorable Shibambo that procedurally we are not correct because there must be oral publication, oral submissions, public hearings, and I just want to be clarified. Are we saying public hearings is still relevant in this case?
No, I think the legal opinion is very clear, Chair, that the publication will be for a limited period and will determine what form what form it will take. The public participation will determine what form it will take. The form we're suggesting, it's a written submission.
Okay, no, that clarifies me.
And that is for 3 weeks that we give to the public to submit to us.
No, you have clarified me. Any other view?
Chairperson?
Yes.
No. No, it's Mr. Raman. I just wanted to point out something that we have discussed as the support team. We know that the committee has agreed to advertise, and we just wanted to bring before the attention of the committee Section 74(5) of the Constitution, which provides that at least 30 days before a bill amending the Constitution is introduced in terms of Section 73(2), then we must publish that in the Government Gazette. And then we also want to indicate that then the Secretary to Parliament will have to refer that bill to the National House of Traditional Leaders. And also the National House of Traditional and Khoisan Leadership Act. Yeah, I think that is
the Act. Yeah, you are correct.
Yes, they also require that the House must, within 60 days from the date of such a referral, make any comments it wishes to make and submit such comments to the Secretary to Parliament. I think the most important issue that I want to highlight is that there is that Section 74(5) that speaks to 30 days and not 3 weeks.
30 days.
So yeah, so I don't know if the committee is going to shorten the period or we stick to 30 days provided for in the Constitution.
What would be the implication of not extending?
I think I don't know if legal services will need to come in there, but I'm just saying that the Constitution talks about 30 days and not 3 weeks.
And then you also
Honorable Chair, if I may.
No, let's allow him to clarify so that when you comment, you also refer to 60 days. What is the relevance of the 60 days?
the 60 days is that while the Secretary to Parliament, if these new amendments that we are proposing, if they are sent to the National House of Traditional Leaders, then in terms of that act, then the National House has 60 days to comment.
But
so
now,
then there is that possibility that they might not submit their comments within the 3 weeks that we would have set aside. So if they delay, then it means that our process is going to be delayed as well.
but if we have given them the time frame, and if they don't react within that time frame, is that our business?
Maybe the issue then, or maybe their argument would be that you are acting in violation of what the Act provides.
Okay, now let's leave it there, and let me take the hands. Honorable Nisuma, Honorable Matlatsi, Honorable Kama, Honorable Shibambo.
Chair, let me step down for now because they've been talking. Then if they need, I'll come back. Thanks.
Okay, Honorable Dibulelo, Zabat.
Thank you. Mdula Stulo, I'm really concerned. I'm really concerned because as much as we appreciate the work that has been done by the administration, I'm really concerned by information that comes in drips and pieces, and that is not consistent, because we were informed about the 3 weeks. Now, looking at the time frame that we have and the time limits that we have, there comes the 60 days and the 30 days. And I think it's unacceptable, because this also warrants us to now navigate through the days and the time and so on, and something that is not necessarily in our control as a committee. So I would want the administration through you, Slalo, to give us at least this information in writing. Not that we don't understand the Constitution and the rules, but they are here to advise us and to assist the committee to operate optimally. That this information be given to us in writing, so how we navigate. Because our position as we're coming to this meeting, it was informed by a view that we've got 3 weeks to advertise as per the advice and information given by the legal services, including the administration. Now, at the very tail end of the process, now comes new things. And even previously, Slalo, without taking too much on the platform, this was the issue with legal services. I'm quite worried about the information that is not consistent, Slalo. Thank you very much.
Let's first get this clear. Who specifically gave us the 3 weeks?
Chair?
Who? Yes, who gave us the 3 weeks?
Legal services.
Oh, Chair, the legal services did not say 3 weeks. It says limited period. And that was the legal opinion. I think we must be fair, because the bill has already been published. And this, we're dealing with an extraordinary thing that is not provided for in the Constitution, as Mr. Kwebu is saying. Is it Mr. And you see, let me read the section. Let me read the section in the Constitution. In the first place, why this thing is very new is not in the legal opinion. Let me read the section at least.
Yes.
It says, 74(5), at least 30 days before a bill amending the Constitution is introduced in terms of section 73(2), right? 73(2). It's any 73(2), 73(2) says only a member or a deputy minister or a member or a committee of National Assembly may introduce a bill in the National Assembly, but only the cabinet member responsible for financial matters may introduce the following bills, then all the financial bills. But we are not introducing the bill at the moment. For now, we are completing the exercise. We are completing the bill, the drafting of the bill. Once the bill has been finalized and we think we have done with this thing, we'll then submit a report to the committee to say we have finalized the bill. You know, the bill is still in the making process. Here they're referring of the bill that is now ready to be introduced to the House. So can we not be derailed? Can we publish the bill? It's only when we finalize the discussion at the end that we then refer to clauses such as this. The bill is still in the making process. Let me just leave it at that for now.
Honorable Kawa, you are right that legal services did not mislead us. They said for a limited period. And now what Advocate Ramano was doing now, he was giving us what the provisions themselves are saying, which is correct. But now you are also correct to say we are not starting afresh subject to these rules. We are in a process. We are completing the process. Like last time when some people said they made submissions, but they wanted to also be afforded an opportunity to make a presentation. And then we gave them a limited time to come and make a presentation. So there's a precedent to that. So I think that we must stay with our 3 weeks and say that we are publishing and we want comments within 3 weeks, and then we will go to the House after that. Honorable Maina?
Chair, I think you have summarized it properly, because what pains, taking from what Honorable Mahlatsi raises, that what the committee support through Advocate Bonani is saying, it behaves as if nothing has happened. We didn't have public participation processes, and also members of the society didn't comment on all the clauses in Section 25, which I find it very disturbing. That how can you ignore such a lengthy process that we engage on? So I'm saying, for me, Chair, for also further is that we even have an open door. We engage sometimes and seek advice to them on the sideline. They've never raised this issue, but most importantly is that we raise before the end of you closed the meeting last week. We raised the issue that we are going to look at the bill and positions of the various political parties and vote on them and then publicize for 3 weeks. Nobody raised the issue of this section, but nevertheless, we're still in the making of the bill, and I don't see any harm. The only harm is that it's more work for them, but it cannot be like this. We don't want to be seen as if we are attacking the administration. But let's move, Chair. For me, we were clear. We've done a thorough homework, by the way. As everybody is aware that we do have legal people that have been advising us, but also we have been communicating also with the parliamentary legal services as the ANC. So we have done a thorough homework on this matter, and we know and we believe that it's the right process to follow. Thank you very much, Chair.
I think it's important that they drew our attention to this section so that we can have a political discussion, which we have just had. And our view is that these sections would apply if we were starting a new process. This is not a new process. We are just completing the ongoing process. So thank you, legal services, for that. But Honorable Shibambo.
So the reason why you're going to face these difficulties and what legal or the committee support is saying is because there is no provision in the Constitution or in the rules of the National Assembly that gives you the right to republish the bill after deliberations by the committee. public hearings were conducted and submissions were made. Nowhere have we ever republished a bill after it had been deliberated upon by the committee. Once the committee has deliberated upon and considered all public submissions, it then tables that to the House for consideration and decision. That is what the procedure dictates. So what we are doing now is an innovation which is inconsistent with the prescripts of the rules of the National Assembly and the Constitution. And that is why if you are going to do a publishing for whatever period, whether it's limited period or longer period, you are bound then to consult everyone who the Constitution says must be consulted for any legislation to be. It's not a new legislation, it's a legislation which we have been deliberating upon for the longest time. So you are venturing into new territory altogether, which is going to get you into wrong prescripts and wrong practices. So there is no need. You have adopted a reactionary amendment of the Constitution. Go and table it in Parliament. We'll vote against each other, and then we'll proceed from there.
Honorable Shibambo, you are right to say we'll have to consult everybody that we are required by law to do so. Now, if we say we publish for three weeks, that means everybody is entitled to comment, make submissions. So I don't see the point that we're making. But anyway, let me not make a ruling. Let me listen to other honorable members, Rosetta and Mamadiso.
Chairperson, thank you very much once again. I am listening to the debate, but somehow I think we may be belaboring on something which becomes very clear. And if we are unable to convey, Chairperson, and though I can see the difference is very minimal and very slight, it's just a question of semantics and understanding. Every committee of Parliament has been accorded a legal support, so that in case of failure to interpret the way ahead or the next route to be undertaken, the legal section will have to come forward and assist in that regard.
Recording in progress.
So that at the end of the day, when all is said and done, we will not be found short. So whether Honorable Shibambu's route is the one that we have to take, or the one which is apparently joining the majority is the one that has to be, I think it is the right time that we invite the legal section for this subcommittee to say, from here, what next? And we will certainly be sure that we shall have not faltered by so means, any means or so. Thank you very much, Chairperson.
Honorable Mrasatla, I think we invited them to do so. They spoke about the 30 days and the 60 days. But we are saying that this would apply if we were starting the process de novo, afresh. But now we are just complementing the ongoing work, and that there's no need to stick to the 30 days and the 60 days.
Agreed.
Honorable members, I think that we have agreed on publication of the bill, informed by what came from our debates and from public hearings. So this is really just a supplementary process to complete our work. And now I think that we should conclude this meeting on the basis that we are going to publish this new bill that we have voted on, invite the public to make supplementary submissions, and for the supplementary submissions, we allocate 3 weeks. And then if we have erred, members have said no, then when we make our report, Parliament will correct us at that point, but we have to proceed as we have agreed now. Can we leave matters at that? Anyone who wants to comment?
I agree with you.
Supported.
Okay.
I agree with you, Samar.
Thank you. Okay. Any counter?
Recording stopped.
Any counter? No counter. So we proceed, and the meeting.
Chair, you must note our objection.
Hello?
You must note our objection to that resolution.
Okay, we note objection of the EFF, and then any other objection? There was also a suggestion that, hello, Honorable Melder.
Yes, Chairperson, I've raised my hand. No, I think the question is, with what do we intend to finish? Do we intend to finish with a bill or a report? But be that as it may, I would also not support the proposal at the moment. Thank you.
Okay, we'll finish with the bill and the report. Honorable Dr. Lodri.
Thank you, Chairperson. Yes, we also can't support it at this particular point because we would very much like to know what the legal services opinion would be and their guidance in terms of the correct procedure, because we now have different views on this. So therefore, we can't support it at this particular point.
There was a suggestion of a second legal opinion. What do members think about that?
I think you have summarized it very well. I think we now have a majority a decision to move ahead in the manner that you have spelled out.
Okay.
Yes.
Okay. Then I think, honorable members, we noted the objections, but we have a majority decision that we move on, and I think we should move on. Then this should bring us to the end of the meeting, unless there's any exigency somewhere. Honorable Lesuma.
It's a minor one, Chair. Thank you very much. Also, just to, from your side, also just touch base with the chairpersons or the House Chairperson, Honorable Floric.
Okay, no, thanks very much. Minor times two, you made very good sense. Thank you. Then the meeting agents. And have a good weekend, and keep safe and look after your family.
Thank you, Slalo. Have a wonderful weekend yourself. Bye, colleagues.
Viva Chair.